Okay, good evening, ladies and gentlemen, and welcome to tonight's August 20th. I call this meeting I call tonight's August 20th Planning Commission meeting to order. Can we have a roll call?
Commissioner Dunbar?
Here.
Commissioner Kronzak?
Here.
Commissioner Leary?
Here.
Vice Chair Finschenko? Here. And Chairperson Anderson?
Here. Let's stand for the Pledge of Allegiance. I believe there's a flag outside. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, that will take us to open forum. This is an opportunity for the public to address the Planning Commission regarding any items not on the agenda tonight. In conformance with the Brown Act, no Planning Commission action can occur on items presented during open forum. To provide public comment, please submit a speaker card. When your name is called, walk up to the back of the projector. We will have a microphone ready for you. Comments are limited to a maximum of 3 minutes per person per item. The chair may reduce the time and the amount, reduce the amount of time based on the number of persons wishing to speak. Open forum will conclude after 30 minutes. However, if there are additional speakers, open forum will reconvene after matters for consideration. All comments submitted via email to the Planning Commission before noon today provided in the Planning Commission and are included in the PC packet supplemental materials. So, do we have any public comment?
Doug Mann?
I'm Doug Mann. Springtown and the adjoining areas of the city north of 580 have been historically given less attention and respect than where we live. And I say we because the five of you and me don't live here. We're all, much further south in the city. And we don't always notice what the heck's going on over here. It was a laudable decision to bring this meeting to the Elks, which is far more accessible location for attendees who want to participate and be respected as equals. So let's talk about equity. If the Garaventa Hills Project had been located in the south side, I have no doubt it would have been conserved long ago. Being situated in the deep north, how long did it take for any of us, all of us, to even notice that this was going on? Residents over here were publicly against the urbanization of the hill as far back as 2011. But the first I heard about it was 29. Ask yourselves, when was the first time you heard about Garaventa Hill and the controversy around it? Maybe we need some sort of north-south awareness committee or encourage the inclusion of greater geographic diversity on committees like this so that, we're not all from over there sort of making decisions about what goes on, over here. Over the past few years as a society, we have gradually learned to our benefit that proactively paying attention to other people who don't look like us, have a different lifestyle, or live under different conditions than us is a necessary activity for a healthy society. Besides, it's the right thing to do. The people who live north of 580 are not like us by virtue of their geography. In the contemporary essence of the expression, they need to be seen. And they want and expect the city to do everything in its power to protect an environmentally sensitive area from being destroyed. Let's stand firmly with them.
If you have a public comment for open forum, not for the agendized item, just for open forum, please. Okay.
So I couldn't agree more with the last speaker. Coming from or growing in, living in Springtown for 30 years, I've been asking questions that I haven't had answered since like 2002, 2004 maybe at the latest. And, things kind of get bounced around. Oh, that's, Public Works. We actually had Placeworks here, and it wasn't here, well, there was one here, but it was at off of Airway. They got the big center there, the Shrine Center. And, we had assigned seats. And a lot of people came with friends and good ideas. We walked in there, we couldn't sit with the people we came with because they wanted to encourage diversity. And anything you said in your little group sort of was twisted and perceived. It was written down as a perception from our facilitator. There was a facilitator at each table. So specific things that we were trying to get across were squashed. We had specific things that we were trying to maybe have our city consider. But instead, they took what you said. My facilitator, who, he still works for the city, he took what I said and put it under a very general heading, and it really wasn't what I was saying. So I really think that something needs to be done to bridge the disconnect, and it can't be an appearance, because when David Early was asking us questions at the time, for our area, I would ask him questions, and he couldn't answer map questions, boundary questions, things that were extremely relevant to, the conversation, and so it got squashed. But thank you for listening, and I know we all have our own backyard in our mind at all times, I'm sure, but thanks for thinking about that, and I really do appreciate what Doug Mann just said. It couldn't be further from the truth.
Thank you. Do we have any more speakers for open forum? No? Then I will close the open forum and move us to consent calendar, which we have none, which will take us to project review, which we have none, which will then take us to public hearings. And we have 5.1, a public hearing to receive comments on recirculated partial draft environmental impact report for Garaventa Hills Project that includes the following land use entitlements: vesting Tentative Tract Map 8094 and site plan design review 13-005. I will hand it over to staff for our presentation.
Good evening, Chairperson Anderson, members of the Commission. My name is Steve Stewart, Special Projects Coordinator, and I'm joined at the staff table with Deputy City Attorney Catherine Mirzu, Acting Planning Manager Ben Murray, and also Rebecca Auld, Vice President at Lamford Gregory Environmental Consultants, is with us. And so I'm going to be juggling a few pieces of equipment here this evening. So we are here this evening to receive comments on the Garaventa Hills Recirculated Partial Draft Environmental Impact Report. And there's a particular focus of tonight's meeting. We'll talk a little bit more in detail later on, but it's specifically to receive comments on the recirculated portions of the Project EIR, or Environmental Impact Report, that talked about available funding sources for acquiring and preserving the property as open space under a particular project alternative that's required to be in an environmental impact report. So we've recirculated only those parts that have been revised from the previous environmental impact report, and we're requesting that comments come in just on those recirculated new parts of the environmental impact report. And that's consistent with the court ruling and California environmental law that will only address or respond to comments on that topic in the final environmental impact report that will be published later on. And that lines up with the appellate court's decision. We'll look at that a little later, that only that part of the previous environmental impact report was found deficient when the project was challenged. The court found the rest of the environmental impact report to be adequate regarding all other potential environmental impacts. So staff and Rebecca from Lanphier are here to answer questions on technical aspects of it, but really tonight's it's not typically a question and answer time. It's just to purely receive comments from the public on that draft document. So just as a reminder, here's the project site. It's shown on our general plan land use designation map. And this is the about 32-acre site here in between Vasco Road and Laughlin Road, just north of Altamont Creek Elementary School and Altamont Creek Park. The general plan designation, urban low 1, and its zoning of residential have been that way since about the mid-70s. Could predate that, but our 1976 general plan designates that as residential. It has been ever since. This is a closer up view of the site, and you can see the terminus of Bear Creek Drive here in the lower right. Will provide access to it. Altamont Creek is a small creek that runs along the south. To the west is the Garaventa Wetlands Preserve, owned and managed by Livermore Area Recreation and Park District. And then the Marilissa development and surrounding development and open space on the project site there. So lots of history on the project. I'm not going to go through all these in detail, but it did start in 2011 and 12 with an application and work on an environmental impact report for a project at the time that was 76 units. It had a 2-lane bridge going over the Altamont Creek from Hawk Street, excuse me, and it required a general plan amendment to increase the density that was already on the property. Did some work on that and reduced in part in response to city staff and comments from the community to reduce the density. So ended up with 47 units. The bridge was removed. It was revised a couple of times, came back to the city council with the bridge removed due to neighborhood concerns. And in 2015, the City Council recommended that project return to the Planning Commission with clear direction to revise the project to reduce grading, make it more subordinate to the landform. And in 2018, the project did return with those council directives incorporated into the project. And then the environmental impact report was also reissued to cover any kind of changes that may have occurred from the project, and did not change the previous conclusions of the original environmental impact report. So the Planning Commission considered that in 2018. The project at this point was 44 units, 38 single-family detached, and 6 affordable duets. The council later approved that in 2019 in the spring and certified the environmental impact report. That project on the screen now is the project that was approved in 2019 by the council. Again, 44 units with some affordable duets interspersed in the development. Has now a bridge back over Altamont Creek from Hawk Street extension, but only for emergency vehicles and pedestrian bicyclists or other forms of mobility. Has a trail connection down at the southeastern corner here. About the lots and houses and other improvements comprise about 40% of the overall lot area. About 60% is the 2 knolls on the property and the open space buffers around the project that will remain in its natural state. And then part of the project and the property that's also owned by the Garaventa family is this 85-acre property that Lafferty Communities is also in contract with them to provide environmental mitigation for development on this site. So this site will be set aside in perpetuity with conservation easement and endowment and management plan for the significant biological resources on that property. So that in 2019, I believe Save the Hill Group did challenge the project, and in 2020, the Superior Court denied that lawsuit, but in 2022, the Appellate Court did remand that decision back to Superior Court with finding that the no project alternative was inadequate because it did not include a discussion of the potential availability of open space funds to acquire and preserve the project site as open space in the no project alternative analysis. The court also directed the city to rescind or remove the approvals and decertify the EIR. So the City Council did that in November of 2022. In early 2023, Lafferty Communities applied to proceed with the project and remedy the deficiency identified by the appellate court. And the city, along with Lanford Gregory, environmental consultant, have been preparing the recirculated partial draft environmental impact report that is before you up for comments this evening. So the court found all of the other challenges to the EIR meritless, including challenges to the biological resources impacts and hydrological impacts to the Springtown alkali sink. Just as a reminder, the applicant does intend to proceed with that exact same project that was approved in 2018. So there's no changes to project impacts that were evaluated in the subsequent EIRs that revised along with the project revisions. And so consistent with the California Environmental Quality Act and the court's ruling, again, we're focused our analysis in this draft document on the feasibility and availability of those potential funding sources. And again, the other environmental analyses included in the EIR withstood all other legal challenges. So regarding those open space funding sources that might be available, we then set off to explore those over the course of the end of 2023 and first 6 months or so of 2024, including several appearances at the Altamont Landfill Open Space Committee to discuss the availability of those funds to acquire the site. There's also funds available for open space acquisition through a Doherty Valley Settlement Agreement. Both of those funds do require a willing seller, and so they were determined to be ineligible for the use to acquire that property as open space. So we also looked at other ways, including eminent domain, to preserve that property and basically take it against the will of the property owner with funds from other sources like the city's Transferable Development Credits Fund and either a general fund allocation supported through a ballot initiative or bond measure, or the city's Open Space and Acquisition Management Fund. So the property is actually outside of the area that's eligible for the Transfer Development Credits Fund money. The Open Space Acquisition and Management Fund doesn't have very much in it, and we use that to maintain some of the open space properties that we have already, like fence maintenance, signage, vandalism repair, things like that. And then the other methods through eminent domain would require pretty significant, legally complicated, and cost-prohibitive fair market eminent domain proceedings, and the use of funds that the city has prioritized elsewhere to provide services. So the city council and you, the planning commission, in your advisory role will take these into consideration when you look at the project when it returns, along with land use entitlements. And we're anticipating that to occur in the fall. So tonight, again, we're here to collect comments on that recirculated partial draft environmental impact report. We'll talk, the next slide has some logistics on where to send those comments. City staff and our consultant will take the comments here this evening, written and verbal. And those comments would be incorporated into the final final environmental impact report, along with responses to those comments, and only those comments that are focused on this topic of available funding sources and the no project alternative would be responded to. And again, we anticipate the Planning Commission and Council looking at the final recirculated partial EIR in the fall. The 45-day public review period commenced on August 30th. It runs through September 13th at 5 o'clock. And again, we'll take the comments received here this evening and treat those just as if you were to email those in.
Real quick, you said August 30th. I think you meant July 30th.
Sorry, July 30th. Yes, 45-day public review comment period. Again, with a September 13th deadline by 5 o'clock to send those to me, please. There's my contact information, and my email address is up there. And if you could include your contact information there in those communications, that'd be great. And with that, that concludes the presentation, and we would just recommend the Planning Commission receive public comments, and we're here to answer technical questions if you have those. Thanks.
Thank you. So just to clarify, the Planning Commission will not be voting on anything or doing anything like that tonight. We're here to receive public comment from the public.
That's correct.
Okay, thank you. Just wanted to clarify that. Okay, then is there any clarifying questions before we open for public comment up here? Okay, then we'll go ahead and. Oh, Tracy? Commissioner Kronzak?
Tracy, it's just fine. Thank you, Chair. Two questions. One is, in the course of your presentation, and obviously the materials that we've received, you had mentioned that this land and the underlying land use was, designated as urban low density from at least the 1976 general plan. Just out of curiosity, has the Garaventa family also owned it since prior to that time as well?
I am not sure of that, but I do know they owned significant land holdings in North Livermore.
Okay, so this is basically, though, from the purposes of general planning, this has gone through two revisions of the general plan, the 76, the 2003?
Three, yes.
And then now it's going to also be designated as such in the 2025-ish general plan as well.
That's right. There was also a focused update in 1988.
Got it. Missed that. Thank you. Second question regarding CEQA, which is, as you know, an area of personal interest of mine. By design, CEQA as a law has been created as a discovery mechanism by the state of California, and the arbiter of those discoveries is the court system by design. Is that correct?
I will turn that over to Deputy City Attorney Catherine Mirasu for an official
Catherine,
answer.
thank you.
If I understand your question correctly, it's that the mechanism to challenge something under CEQA is the courts?
Yes.
Yes, that's correct.
And secondly, now that this has gone through the Court of Appeals, the court have made their ruling and arbitrated on this accordingly. Do you happen to have the actual text of the arbitration available that explicitly calls out this frame and scope that we're considering tonight?
Yes, I do.
Would you be willing to please read that into public comment
Sure. So
or a summary of it?
yes.
I know how these things look.
So the Court of Appeals said that the EIR, that the city was required to set aside the EIR in the project approval because it failed to provide adequate information about the funding available for the no project alternative.
And it dismissed all of the other challenges accordingly.
That's correct.
Okay, great. Thank you.
Well, thank you. Anything else? Okay, then I will go ahead and open up the public comment. Remember, submit a speaker card, and then when your name's called, walk up to behind the projector, and you'll be given the microphone.
Doug Mann.
I am Secretary for Citizens for Balanced Growth. CEQA has provisions to re-trigger an EIR when certain new information is obtained about an environmentally damaging project. So we'll be starting all over again and continuing for as many years as it takes, extending far beyond the NPA. Although the result of tonight's meeting will just contribute to a reverse loop on the CEQA flowchart, receiving comments might still do some good. Let's concentrate on the weirdest part of this whole thing, which is the interactions with the trustee, Lisa Quisito. The staff report claims that Quisito is not a willing seller. We put this expression into the DVSA when we settled the lawsuit to prohibit eminent domain purchases. Quisito is a willing seller and actively engaged in the process of selling this asset under self-imposed restrictive terms. Her preferred buyer, Lafferty, has refused to buy for 13 years. Quisito claims they are restricted by contract to sell only to Lafferty. What she doesn't say is it's an option contract. Lafferty pays them to not sell to anyone else. But it's also not perpetual, but one that renews on a regular basis. In the renewal periods, she can sell to anyone. February 2nd, Livermore offered $868,000. Quisito's February 5 reply defines their selling price as $3.5 million. Staff paradoxically followed up February 29th with an offer for $1.74 million. This offer was designed to fail. Other than to mock, aggravate, and waste the owner's time, what possible purpose did that serve? They could have responded, if the city offered $3.5 million and you were not under another contract, would you consider it, for example? We don't know how many other insults Quisito may have endured over the years, but one might wonder if this sort of thing explains the accelerating tone of resentment in her letters. Here's where you can help. Although you're not required to take any action, you do have the option to help cut through the fog. Ask your staff to engage a professional mediator. A neutral party may be able to find solutions to the fractured relationship between the city and the seller. As an EIR expense, the developer will even pay for it. You could also request your staff contract with an actual real estate agent to represent the city. It costs nothing, and there's no better way to consummate a real estate deal than to give marching orders to a motivated professional. Both of these activities can occur in parallel. Again, you're not required, but if you do nothing tonight except passively receive comments, I'm done. One has to wonder what you as public servants are actually doing to help the community. The RP Draft EIR remains inadequate.
Bianca Covarelli.
Good evening. Sorry I can't stand. I literally had knee surgery 4 days ago. But this is a very important topic to me. My name is Bianca Covarelli, and I'm Save the Hill Group. I appreciate your time this evening very much, for your dedication and hard work, for all of your planning throughout our beautiful town of Livermore. It's very special to me. Initially, I'd like to state for the record and remind city staff that we do have a legal right to make comments tonight on the draft EIR, and the directive to limit comments to strictly funding is misinformation. And this is why I argue that significant new conditions and new information have come up over the last few years that will re-trigger the requirements to amend the EIR and recirculate. The city's project page has the 2014 final EIR and the 2018 reissued final EIR. Most of the reports are from 2014. The only difference between the two projects was density of the development, no new studies. The reports in the final EIR are quite old. The city lost a presidential legal judgment that required the city to set aside the certification of the RFEIR and the approval of the project. What they didn't mention is that they handwrote a letter to the California Supreme Court in association with other building communities. And the California Supreme Court came back and said, after the City of Livermore requested that the ruling be tossed out from the appellate court ruling, and the California Supreme Court said this: not only are we upholding this presidential ruling, but you are no longer allowed to appeal this ruling. So that says a lot. And maybe there are issues about the EIR that didn't come out in the courts because this other issue is so important. So I'd just like you to consider that. Over the last few years, I have been diligent in research and committed to consulting with experts on the pertinent issues, new information and conditions regarding the special hill. There are many lengthy studies by those experts being prepared now. The process isn't quite complete as to what will be in the record yet, but comment submissions will be made prior to the September 13th deadline. The environmental consultant may be overwhelmed with the plethora of new information and the abundant additional work that they may be required to perform. Regarding the funding issue, we can all agree the second the court's the precedential ruling wherein they vacated the EIR and the project, we can agree that the valuation on the land declined significantly. The comment made of the current valuation of the hill being 15 to 20 million is beyond erroneous. Misinformation and a possible attempt at hindering informed decision-making and public perception. The question is, the city is in good faith honoring the court's position that on a piece of land that is so environmentally sensitive and rare, it's a very unique diversity, and there's nothing like it anywhere else in our state. Conservation should be considered, and that's what the court said. I was in the hearing when they said it. The property was listed at various times since 2017. The listing price in 2017 was $4.9 million. The city's recent offer of over $800,000 and then $1.7, it wasn't a fair market value offer. No wonder the landowners rejected it. That's why they're being considered an unwilling seller. They are clearly a willing seller.
Thank you. Could you finish up your
The
comments?
city contends the landowners are not willing to sell. I feel that if a bona fide fair market value offer was offered, they're a reasonable seller, they would consider it. This loss by the city and the courts was an exit to that option that Lafferty's holding on this property. But do the landowners know that? Do they know that there's funding available to purchase? I request tonight that you, the Planning Commission, take to heart the magnitude and the time spent on this proposed project. It's been over 12 years, and I can personally attest to that. I've been involved. I can recommend that you send this back to staff and demand preparation of an accurate, proper, updated, and current EIR. Thank you so much for your attention.
Thank you.
Vladimir?
I'm gonna sit too, since you guys are all comfortable. For one, I think you should have let her speak all the way through, because she underwent surgery, as she said, 4 days ago, and she is saved the hill, and I think what she has to say is pretty important. I don't think there's any reason to be concerned over the 1 minute that she takes. Just had to say it. You know, I drove her here myself, and she's clearly committed. The other thing I'd like to say is hello to my old friend Steve Stewart. I remember when we were at the Garaventa meeting a few months ago, and my impression was that you were dreading that meeting, and I don't blame you because it was very long and drawn out. I'm surprised to see you back. I think what that says is that everybody's got a price, right? And in this case, it was worth it for you to come back on. On the topic of that, your whole argument seems to rest on the idea that the landowner is not a willing seller. And as Doug and Bianca pointed out earlier, it's bogus because they're trying to build as many homes as possible on this land for 10 years now, and working with the developer. These people are trying to make money. The reason they're not a willing seller to the city is because you ridicule them with $800,000. The other thing that I found interesting actually in your report, since we're discussing the no project alternative, I thought you should mention how much the land is worth. Do you know how much it's worth? I know they said it earlier, but do you know at this point as the city? Because a few months ago you told me it was $15 to $20 million. And as Bianca said, there's some text in CEQA that I was reading earlier, but something about informed decision making and public participation. And I think that when you lie about how much the land is worth, even though you have letters from the landowner and you have, I mean, this data is easy to find. And you get this $15 to $20 million number and people believe you because you have the power of authority. I think you're misusing it. So anyway, this no willing seller argument is false, because hypothetically speaking, if you throw $100 million at them, I bet they would change their tune, right? So it's just a matter of money. If you make a fair offer, then they will sell. They're probably as tired of this as anybody else, of this charade that's been going on. I guess that's it, huh? I'm trying to practice not writing any notes so that I get better at public speaking, but I might have forgotten a few things. It's okay.
Thank you.
Connie Copps.
Hi, I'm here about 5.1, and it's not clear in the beginning, but it'll be clear as I read on. Our public hearing, item 5.1, 13-005. Our city is unclear with its general planning for all of North Livermore and lands it's preserving. There is an opportunity cost to all living in this area, as the boundaries of who is responsible for what with landowners and shell companies makes getting clear maps and any questions answered with honesty impossible. It is my firm belief that a general plan with zoning for it should be clear and concise so that all districts together can view it in its entirety, as all are affected by what you do and what you approve. It's impossible to give honest input without that, without the big picture. I do think also that this land, because it's got a B after it, I forget, the parcel number is like 99B, that it is a child to something. And when I called the county about, I think it was that parcel, they couldn't tell me for some reason who owned it prior to them. They said that wasn't public record. So I don't know why, and I might have messed up something too. But I really do think it's important to go over with your whole community the past history and why things were preserved, and again, update your planning to include, modern day thoughts. Even when like Public Works was coming to my HOA in the other part of Springtown, when Darren Greenwood was telling everybody at my HOA that the city owned our property, and the golf course was still going. So dynamics around it have also changed, and there's an opportunity cost for those other people who also might want to propose some kind of building to you. So try to be fair. I say take your districts, divide your housing allocation by your number of districts, and at least try to balance it out and trick it in. I don't think that Midtown, well, we're getting on another subject here, so I'll stop. But thank you for taking what I said into consideration. I really appreciate it. Thank you.
Thank you. And that is it for public comments. I will close the public comment period and bring it back up here to the commission for anybody that has any comments. Anybody? Any comments?
Yeah, I believe it's in the report, but staff, could you go over the reason for the offers as they were given previously?
Sure. The initial offer was based on open space prices that we've used over time to acquire open space, ranges anywhere from $8,000 up to $15,000 an acre. So somewhere in that range. And then the final offer, I know there was one, I think there was one in between. The final offer of 1.78 million was direction from the, or was suggested by the Altamont Landfill Open Space Committee to be in line with an acquisition that city partnered with East Bay Regional Park District on land across Laughlin Road that had urban designations. It was about 40,000 an acre. And that project, that land is now held by East Bay Regional Park District. That was the price. So they kind of did some quick math, and that was the amount per acre, I believe, that came up to that number. And I'd have to look at the offer. I think there's an offer in between those two numbers that I'm not. Oh, yeah, and then finally looking at an offer to look at the fair market value of the property. In other words, have it appraised at its current value based on its residential designations, which would likely drive the cost up pretty significantly. And those are some of the numbers that are mentioned in the report.
So is it fair to say there's a cost basis of the parcel as open space land, and there's a cost basis of the parcel if developed in terms of its market value?
That's right. So we made an open space value. We made an offer that was consistent with another offer for urban designated lands that we were able to acquire with the East Bay Regional Park District, and then offered to engage at a fair market value conversation.
So that offer was comparable to the per acre cost of other parcels that we've acquired recently?
That's right.
Okay. I might have more, but I'll pass off for a moment.
Commissioner Kronzak?
One quick follow-up to Commissioner Dunbar's question. There were two sets of numbers in those reports. Ones were the numbers in the offer letters that you just described, along with the valuations and where they came to and from. The question I have is, if all bells were chiming, and ultimately, the other set of numbers that I were considering were the city's availability of money at all to make an offer that would be double or triple the 1.7 million that was stated. My understanding from all the financial reports attached to this is we simply would not have the money to actually make that kind of offer as held against our other priorities and things that we are otherwise maintaining. Is that correct?
I think the short answer is yes, and some of it would depend upon, a price that you could negotiate.
Right. Second question, are you aware of any community-based efforts to raise money to acquire the land from the property owner at a value that would be higher than the $1.7 million that the city offered?
I am not.
Okay, thank you.
Thank you. Yeah. Commissioner Leary.
Thank you. I had more of a process question. I saw in the staff report there's reference to the California Court of Appeal First Appellate District. So is everything that we need to know is in that judgment that came from the court in terms of the reason we're here tonight, the reason we're recirculating the EIR? Do I have that right?
Yes, that's correct.
Okay. And something, because it caught my ear as you mentioned, was it the property you gave a value of, was it $40,000 an acre? Was that the Farber property?
Yes.
And that's what the judge, I think, mentioned specifically in the court case, was the Farber property, right? As a comparable?
They do.
I saw that
reference
in there. He
sorry.
gave that as an example. So just since we're only doing comments tonight, I just wanted to highlight a couple things that I saw in the Save the Hill group versus City of Livermore. The judge mostly cited other cases, but I found a few that he, just to be sure that when we're recirculating, the comment from me would be to make sure we look at the judgment and see what the judge is asking for, and so it could be evaluated, in the end by the decision makers. But one of the comments was the description, this is citing the Fish and Game case, the description must be straightforward and intelligible, assisting the decision maker and the public in ascertaining the environmental consequences of doing nothing. I'll just do two more. The other item the judge said was the failure to include relevant information precluded informed decision making. And I think he mentioned that he was citing the city council meeting and how there wasn't enough information on the no project. So the judge mentioned that. And then one more, lacking adequate information regarding the no project alternative, the city council could not make an informed, reasoned decision on whether this project should go forward. And so it goes along in that vein, and I didn't see anything else in that 8 or 9 page judgment beyond the no project alternative. So that's my comment.
Thank you. Okay, Commissioner Dunbar.
Just to be clear, in the scheme of the second offer that was made, the staff of the City of Livermore made that offer because of the directive of the Altamont Open Space Committee at that price. Is that correct?
That's correct.
Thank you. I think the comments that I heard tonight, I learned some new information that I appreciated about contract terms. I'm hoping to hear more about potential new information that may be of use when that letter comes in. Forgive me because I take notes because I wouldn't be able to keep up with all the things, but notes are good. But I think that as by law, all the comments received tonight will be responded to where appropriate. And we'll have to make a final decision when it comes back to us at that time.
Thank you. Anybody else? Yeah.
I just have one question for staff and maybe the environmental consultant. What would trigger a new EIR, and how would that be discovered in this process?
So I think with the court case, that's not as straightforward of an answer as it usually would be. Rather than answering tonight, I'll consult with your legal counsel and we'll have a better answer in the final EIR.
Thank you. Anybody else? I just wanted to clarify one thing. Do we legally have any authority to take any action tonight as a planning commission?
No, you don't, other than the advertised activity in the notice, which is to receive public comment.
So even if we really, really, really wanted to, we legally could not?
That's right.
Okay.
Correct.
Just wanted to clarify that. Also, just a clarification, the reason we have the time limits for certain amounts for certain people, for all people, is that it's the same for everybody, that everybody gets a chance to speak. And then I don't have any further comments. I just want to thank everybody for coming out tonight. It's really appreciated when people come out and come to these and actually make their voices heard. I really appreciate that. And please, when this does come back to us, whether we end up doing it here or we end up doing it back at the council chambers, please come, give your comments. And I really appreciate all of that. One thing that I will not tolerate, and please don't assume that anybody was a speaker of this, but I'm just going to say this as is classifying that we as a commission do not care about any certain areas of town. I want to clarify, I lived 600 feet from this building. I spent more time on the commission as a resident of Springtown than I did anywhere else. So I do not classify people as, not caring for certain areas of town. Because I do truly care about this side of town. Also, in future, please refrain from any attacks on staff, like calling them liars or anything like that. They are doing their job to the best of their ability. If you truly do think that they are purposefully lying, there are legal channels and public records requests that you can make of them. But they do everything in the public eye and are public servants. So please refrain from any personal attacks on them. And again, I just want to reiterate to everybody that came out tonight, thank you. I really do appreciate it. And we will definitely delve into all the information that was provided tonight and when it comes back around to us. Thank you. Is there anything else from the commission? Anything else from staff?
Not on this end, no.
Okay, then that will end 5.1, and that will take us to item 6, which there is none, and that will take us to item 7, matters initiated by Planning Commission and staff. Does anybody up here have anything? Yes, Commissioner Kronzak.
I actually do want to piggyback on one of the notes that were made by several of the public commenting folks here tonight. I'm actually a huge believer in community engagement as part of democracy and democracy in action. And honestly, if we have the opportunity to take this on the road like we've done tonight, even though tonight we know why we're here because the main council chamber is under renovation, but if it is not a logistical nightmare for staff to take this kind of meeting on the road occasionally so that neighborhoods can be reached like this one, I would absolutely love to know if that is possible, and if we can do that more often, I would be in full support of it. And also to piggyback on the chair's comments, I live about 1.5 miles that way. So yeah, North Livermore is an area that I do believe is one that I care about deeply, and one that I know is sometimes feels like the redheaded stepchild of Livermore. So there you go. Thank you.
Thank you. I have one item, and it is that we continue to pressure Caltrans about the First Street Springtown Boulevard overpass. I recently rode my bike across it, not tonight, and I deliberately did not ride my bike tonight because of that incident. I've said it once before, I've said it many times before, that we really need change there, and I know it's very frustrating because that is Caltrans owned, operated, and maintained. But as a city, we can still apply the pressure that we can to Caltrans because it is truly in need of some work. Yeah. Anything else up here? Yep, Commissioner Dunbar.
On that note, I believe we had what we wanted to do to repave that stuck in a design standard decision document for, I don't even know how long, but I did ride my bike here over that overpass, and it's still not fun. It's been not fun for a long time, and it needs to be better, and I think everybody knows that. Keep pushing.
Thank you. Do we have anything from staff?
No, nothing extra from staff.
Okay. Nothing else? Anybody? Do you want to ask staff personally afterwards, or ask?
I mean, it's on behalf of all of us, and that is, I wanted to ask explicitly, the Planning Commission conference is happening in September, obviously, and the Tuesday night following, while the conference is still happening down in Riverside, there is an ordinarily scheduled Planning Commission meeting that it might be wise to see if we could potentially move items away from, since all the commissioners will be at the planning conference in Riverside. That was it.
Okay. Yeah. So anything else? And we got nothing from staff? Okay. We're all good? Okay, then I will adjourn this meeting to our next regularly scheduled meeting, September 3rd, I believe. Sorry if I got that date wrong. Let me double check. Yes, September 3rd. Okay, thank you. This meeting's adjourned.